You all ready for your big camping trip?
Yeah, I'm excited. Excited. It's gonna be
Gonna be
hot, so
yeah, like
yeah,
100 hot.
yeah. Good morning, Tom and Kim. We'll just wait for a few more to arrive here. Thanks for joining.
So Ashley, it is 11 o'clock officially. The
It
the
is.
pur- the, the purpose of our visit today is both for a live audience, and then we found that more often than not, the recordings and the videos, they actually get more traction afterwards. But
Mhm.
Tom and Kim, we're happy to see you on here. We're despite the fact that there's only two, we're still going to keep this as a little bit of a general overview, as opposed to a specific conversation with just the two of you, knowing that there's going to be some folks that may or may not be interested in the specific conversations that you might have. Happy to take those questions afterwards, of course, but we're going to keep the topic kind of on topic, so that the content follows the title. And as folks watch this on the South Dakota Truckers Association webpage afterwards, they'll see what they came for. So as typically people log in, a minute or two late. So maybe Ashley, you can start with a trucking joke. Not so
uh,
much.
what did the trucker say to the
Oh boy,
chicken?
what?
Why are you crossing the road? I have to drive there.
I'm guessing you just made that one up.
I did.
Oh, funny. Okay, so it's 11:01. Maybe somebody will join, but there's probably no point in waiting.
Yep.
With fingers crossed, maybe we can just kind of get cooking. But before we do, let's do some quick intros. My name is Jason Botwell. I'm a partner here at Pro Resources, and Pro Resources general description is we're an HR outsourcing organization. Organizations that are big and have internal HR lean on us to do some of the tactical work for them, filling out paperwork, onboarding employees, hosting difficult conversations, et cetera, and staying on top of policy, procedure, and legislative shifts, such as the one we're set to talk about today. Small and medium organizations, well, we just become their HR department for them, and we provide all the things that a large Fortune 500 type HR department might provide for an organization that's staffed internally. Ashley, maybe you can introduce yourself and your role and what you do for some of our customers, and then we'll get going.
Yeah, absolutely. So my name is Ashley Drews. I'm an HR director at Pro Resources. So what that means is I am working with our clients every day on the phone, via email, talking with them about issues that they might have going on in their workspace, planning for the future, in whatever capacity that might mean. So it may mean, doing some succession planning for that next generation. It might mean, working on severance agreements. It might mean difficult conversations and anything in between, in addition to law updates.
Yeah, so those difficult conversations, I'll just kind of offer a for example. Maybe we need to, as a partnership, you need to move on from a staff member who's been with you for a while, somebody that maybe somebody that's even related to you. Sometimes those conversations are hard to have, or maybe it's two employees aren't getting along. And as we've heard a million times, it's anecdotal, but it's true that people don't leave organizations, they leave supervisors. So if a supervisor and an employee aren't getting along, well, it might be hard for you or others within the company to play third party arbiter in that situation. We'll pop in, we'll sit face to face with your staff and work through some communications best practices with the expectation that maybe we can save somebody that's a good employee from leaving the organization and having to fill that seat all over again. So I'm sitting in Sioux Falls right now. This is where I operate home base. Ashley sits up in Detroit Lakes, Minnesota. But we've got a legion of HR folks and others that work on benefits, on HR technology, so on and so forth. So if there's an interest, I'd love to chat with you. And that's it. Ashley, take it away.
Perfect. Well, thank you everyone for joining. Appreciate you taking this time to learn about, the new salary updates that are going to be taking effect here, and one that already has. So we'll just go in and dive into it. All right. So the salary update is two-phased, meaning there was one that happened on July 1, so a few days ago here. The salary threshold prior to July 1 was $35,568. And what that means is you couldn't have anyone in an exempt position be below that wage. So that wage is now $43,888, meaning if you had anyone, in between the wages of $35,568 and $43,888, you'll want to take a look at those. So what that means is, a per week salary of $8 or $844. So employees who earn less than this amount and are paid a salary basis are eligible for overtime pay for any hours worked over 40 hours in a work. And that highly compensated number effective July 1 is $132,964 for anyone that might fall into that category. Okay. All right, the salary update number 2, this one is set to take place on January 1. So what that does is it changes the $43,888 that we just talked about up to $58,656. So a huge jump effective January 1. The new law also provides automatic updating for the salary threshold every 3 years. So in 2016, there was a very similar rule that was announced that would have increased the salary threshold and provided automatic increases. However, this was an Obama administration rule and it was held up in legal challenges prior to its implementation, and it did not survive the Trump administration. So why this is relevant is with the timing of the final rules publication on January 1 prior to the November 2024 election. It will be interesting to see kind of how that all plays out and if this salary update will withhold that administration change. So employees, as of right now, what we know is January 1, anyone who earns less than $58,656 and is paid on a salary basis would be eligible for overtime after working 40 hours in a week. And that highly compensated number changes to 151, 164. We had a question from Tammy. Is anyone else having trouble with audio? I don't know. I'll increase my volume and see if that helps.
I'm guessing that won't help. Typically, yeah, I see others saying no audio issues here, so I can hear you just fine as well.
Okay. I'm gonna keep rolling, and Tammy, maybe the replay will assist.
Yeah, so the replay, Tammy, we'll record this, and we can get a copy of it over your way afterwards. So there's a way for you to watch it post live, and hopefully you won't see the audio issues at all in that scenario.
All right, so we'll move along to the exemption criteria. So employees who are paid on a salary basis must meet certain exemption criteria. This law update applies to the executive, administrative, and professional exemptions. So if this is the first time you're kind of hearing about this exemption criteria, or maybe it's been a while since you've reviewed your salaried employees' job duties and their job descriptions against the exemption criteria, now would be a good time to take a look at that with your HR manager and determine if that person is truly exempt. All right. So the administrative and professional exemptions are two that I get the most questions on. So we'll just quickly review, what that means and what those exemption criteria, the main points of them are. There are other factors in there, but just to kind of hit the high points here. So for the administrative exemption, that means that the employee's primary duty must be the performance of office or non-manual work directly related to the management or general business operations. And they would also exercise the discretion and independent judgment with respect to matters of significance. So pretty subjective, but we'll move on from that. If you have specific questions, let me know. On the professional exemption, employees' primary duty must be performance of work requiring advanced knowledge, predominantly intellectual in character, and consistent exercise of discretion and judgment. The advanced knowledge must be in the field of science, learning, must customarily be required prolonged course of specialized intellectual instruction. So it can't just be someone who's in a professional type role. Okay, so we're an employer. What do we do here? We have a huge pay gap in what our employee makes and what the salary will be in January at this point. So what we want to do is we want to review our options. We want to update any affected employee's salary amount to meet the new threshold if the budget allows, if you've determined that they do in fact meet the exemption criteria. Change the employee's pay type to be paid based on hours worked is another option. So they would be paid hourly versus salary, or they would be paid salary but non-exempt would be your third option. So in either option 2 or 3, the employee would have to punch in and out, because you'd have to be able to determine how many hours they work per week. Those are really your 3 options with this law at this point. So with that, and how to prepare for a decision is you'll want to make a list of the employees being affected. So those that are earning between those two salary threshold amounts, if you haven't updated for July yet. And then determine if the employees meet the exemption criteria. And then analyze their actual hours worked to determine any potential financial impact that might incur, maybe in switching them to hourly versus salary. All right, so there's some options and there's some impacts with each of these decisions. So if you switch them to, an hourly pay type, do we simply, and this is a hypothetical question, for you to answer, but do we simply divide their salary by 40 hours? Or do we factor in any potential overtime that employee might have during the year? Incentives and bonuses, are incentives and bonuses only for salaried employees, or do hourly employees get incentives and bonuses too? And how might that impact that pay if they are switched to hourly? Some companies have different benefits packages for hourly employees versus salaried employees, so that's another thing that you want to keep in mind and look at. Time tracking. So tracking non-exempt employees' time might require planning, maybe some reconfiguring or some technology options for time punches, which we do have. So there's some other impacts here as well. So employee morale. There can be some certain prestige with being a salaried employee for some people. So you might want to, they might consider it a demotion if you're now requiring them to punch in and out, and what other impact that might have on the company or the culture. Flexibility. Being paid on a salary allows for certain flexibility, which sometimes works in the employer's favor, and it sometimes works in the employee's favor. So if you take away their advantage, then you're kind of, one-sided in that part of the equation. Advance notice. So employers should provide advance notice when switching an employee from, salary to hourly or vice versa. And also indicate what is required of them going forward. So punching in and out, meal and rest breaks, that kind of thing. This advance notice is required in Minnesota if you happen to have any employees that are based in Minnesota. Not required in South Dakota. Company equipment policies. Do you limit the use of company laptops for non-exempt employees so they aren't working during non-work hours? If so, you might want to update the policy or take a look at that. All right, so I do have some information on some other upcoming employment law changes that are more relative to Minnesota. Would anyone be interested here? I'll just go through them and you can let me know if they're not relevant for you. So there is some changes to the Pregnancy and Parental Leave Act as well. This is for Minnesota
If
employers.
nothing else, Ashley. Yeah, I don't mean to interrupt you, but help us understand where a South Dakota-based organization, of course, the group here, South Dakota Truckers Association, but help us understand, as you're talking about these rules, why these rules and policies may be relevant to organizations that are based in South Dakota, based meaning have primary offices there.
Yeah, absolutely. So for trucking specifically, if you have truckers who drive through Minnesota, they may be impacted by things like the Minnesota Earned Sick and Safe Time law, which I don't have as a slide here, but the law for Minnesota Earned Sick and Safe Time is if an employee works in Minnesota for 80 hours during the year, then they're required to earn, Minnesota Earned Sick and Safe Time. So even if your company is based in South Dakota, most of your employees are based in South Dakota, you have a job in Minnesota, or you have a trucker who drives through Minnesota for 80 hours plus per year, there's other laws that might be relevant for you. So certainly things to know or keep in mind, as you're thinking about some of that stuff. And working with an organization like Pro, who works in multiple states, can be a huge benefit to an organization that has employees working in multiple states, because we're well versed on, a lot of those laws.
if nothing else, this next section will make you grateful that you're not primarily located in the state of Minnesota. Crazy time.
Yeah,
Um,
yeah.
I just saw a chat-based question there, Ashley, pop up. Sorry to interrupt you again. The question was, what was that law again, from Tom? I think Tom, the law that Ashley had mentioned there was earned sick and safe.
Yep, Minnesota earned sick and safe time.
So you don't have a slide on that, but can you offer a little bit of just a verbal overview as to what Minnesota sick and safe
Absolutely.
is?
Yeah, so what the Minnesota earned sick and safe time is any employee who works in Minnesota for 80 hours or more throughout the year is required to earn this Minnesota earned sick and safe time. And what that looks like is it is 1 hour earned for every 30 hours worked, up to a maximum of 48 hours for the year. So, and what they can use this time for is things like doctor's appointments for themselves or their family, school closures, if they're a victim of domestic abuse or violence, preventative care, maintenance, health appointments for themselves or their family, inclement weather, school closures, that kind of thing. We do have a system that we track all of that time as well and can allocate those hours, you know, for Minnesota versus South Dakota in addition. So that law was effective on January 1, 2024. All right, so we'll move to, if you have any other questions on that, feel free to send a chat. Jason, would you mind reading? I saw a question
Sure.
pop in.
Yep, sure can. So, Carrie, and if you want to unmute yourself, you can certainly ask the
Yeah.
question yourself too, Carrie. But the chat message says, so if they work those 80 hours, is the sick time only on those 80 hours or on the whole number of worked hours?
Yeah,
And
good question. Good question. So they have to work 80 hours in Minnesota to be able to utilize this time, but they start earning it on hour number 1 that they work in Minnesota. So if they only work in Minnesota for, you know, 40 hours, they've earned some, but they can't, you know, utilize it yet. So, and then they would earn that time on any hour worked in Minnesota.
Okay, so follow up from Carrie then was, how do you factor this for non-hourly employees like truck drivers, those that are paid on, now this is me expanding a little bit, but those are those that are paid on load and route?
Yeah, great question. We have a lot of trucking companies that we work with and we've received some legal advice on this, you know, a few different times and it's challenging to put it lightly. So we would look at kind of how things are organized for the company. For our Minnesota-based clients, what we've done is look at their log journals and been able to determine, you know, what's Minnesota versus what's not. I You know, it can sometimes be a little bit of an administrative nightmare. What we've had some other clients do is just provide the entire amount if they feel like they would qualify. So it's kind of a situational based thing for trucking companies. And that's something that you would work with your HR manager on to determine what the best solution is based on the legal advice that we've received. Right. So Minnesota, again, pregnancy and parental leave. So this is new. So employees are required to maintain coverage under group insurance policies. And the other part of that law expansion is that the 12-week entitlement to pregnancy and parental leave may not be reduced by any paid or unpaid leave that the employee takes for prenatal care. All right, in Minnesota as well, effective January 1, 2025, employers with 30 employees or more are required to post pay ranges in job postings. Some kind of interesting things here. The range cannot be open-ended, and if there is not a range, a fixed pay rate must be listed. And it must be based on a good faith estimate. So be glad that you're not in Minnesota. That one's going to be a bugger for a lot of companies. Saliva drug testing is now permitted as well in Minnesota. So must be conducted pursuant to a written policy, does not require the utilization of a testing facility, which is huge for our employers here. They can do it on site, so that's a big win. And I mentioned the Earn Sick and Safe Time. This one, I don't have a full slide on it, but there is some changes that are proposed and expected. So we'll see what happens there. Nothing that I've seen come through yet, so we'll keep an eye on that. Jason, do you maybe want to touch on how we help?
Sure. So let's see here, making sure I wasn't on mute there real quick. So essentially, and mentioned this a little bit earlier, but we work with organizations we keep our ear to the rail. We advocate on behalf of small business, doing our best as part of a national organization, kind of like the Chamber of Commerce, really lobbying for and encouraging legislators to enact and enforce logical and beneficial employment law. We do that kind of on the top side of things, but where we get dirty with our customers, where we can get our hands dirty, is working as a human resources department external to your organization. So Ashley, as an example, as you serve one of your customers, maybe you're there one day every other week, as the in-house HR department. People get to know you, they understand who you are and what you do for the organization. We've got a benefits team that helps organizations. As an example, an employee might call their internal HR department and say, "Hey, I just found out I'm pregnant. I'm excited. Does this impact anything? What I need to talk about benefits? Maybe there's a new plan that I should be considering, or I need a root canal because I broke a tooth off over the weekend, opening a beer bottle with my tooth. Who's in my provider network? Some of those kind of things. Maybe that's a bad reference, Ashley. But all of those things, benefits related, that somebody that's employed by a large organization would call their internal HR team for, you call us for. We take care of payroll, all of the tax component of it, paying the providers, meaning the medical providers, if there's any garnishments, we pay the feds, we pay the state, et cetera, et cetera. We provide safety training and well-being training, because everybody knows that a safe workplace is a less expensive workplace, and improves morale and reduces turnover. Same thing with well-being. If your staff have half an hour for lunch and there's a Casey's directly across the street, they're probably going to get themselves a $2 gas station burrito and a Monster Energy drink, maybe a Slim Jim and a pack of Marby Lights. Not exactly the best way to encourage productivity with your staff. So if you give us the opportunity, we'll come in and talk to staff and encourage them along the way as they individually benefit and as the institutions benefit from having a healthier work staff. Healthy work staff is more productive. They're a little bit less likely to trip and fall on the job, less likely to use sick time, et cetera, et cetera. Workers' comp, we provide investigations. We had one South Dakota-based trucking company had a driver down in Texas not that terribly long ago, was doing a strap down on a flatbed, had a shoulder injury as a result. Well, turned out that guy was a big faker, and an investigation helped us understand that he was working cash. He was working for cash on a concrete project for a friend of his who owned a construction company. So workers' comp claim eliminated, cost savings delivered to our client as a result of that. We have a technology platform that helps with recruitment, retention, application tracking, time and attendance, and documentation of the employee journey. So really all of those things are just surface level as to how we can potentially help. But maybe the greatest thing we can provide for an organization is insulation from risk by providing real HR expertise as opposed to the Google version of it or the gut feel version of it. Unfortunately, we're seeing more and more nuclear verdicts. If you were to go Google right now how to sue your employer, there's almost a how-to guide in there on how to get that done. And we're here to help you with all of those things. Morale, capacity, taking things off your plate, reduction in turnover, and insulation. So that's kind of a quick sum total on the how we help. So Ashley, if you had something else, go for it. Otherwise, we've got another question here
Yeah,
from Andy.
perfect. Yeah.
So the question, I'll just read it out loud here, is from Andy. It says, what do you recommend to have on record or file for administrative exemptions? Or what would the Department of Labor ask for if they were to do an audit in the case of a question?
Good question. That is where you'd want a very well-written and up-to-date job description. That's going to be your best defense. Pretty simple in that regard. Yep. And then, you know, of course, be able and I don't know if they audit, they may or may not dig this deep. But you may want, you know, an explanation or how those job duties align with the administrative exemption. I mean, again, you may not need that depending on how deep the auditor gets with you. But a good, well-written and up-to-date job description would be your best defense.
So I'm going to ask a different question. Essentially, the opposite question is the one that was just asked. But for somebody who's non-exempt and is below the 56,656 or 50, is it 53,656 threshold?
Yep.
So a non-exempt employee, how do we keep records then to make sure that they're not kind of accidentally working overtime, or that they're being paid according to that policy for those that are non-exempt?
Yeah, so they would be required to punch in. So if they're non-exempt, it doesn't matter if they're salaried or hourly, they would have to be punching in and out to be able to verify those time records, and those time records are required to be kept for a minimum of 3 years after the termination date.
And there's a million tools out there that can do it. We've got a couple options if you were to engage us, but there's other tools out there as well. And if that's something you have questions on, we'd be happy to help you with that particular topic if you're interested.
Absolutely. If there's any other questions, feel free to pop them in the chat or unmute yourself or reach out, and we'd be happy to help.
Just for record keeping purposes, if anybody has a pen ready, my phone number is area code 701-200-1400. Of course, my email's up on screen as well. Ashley's one of 5 HR people that we have available. She may be assigned to work with you. Otherwise, we just brought excited to introduce a gal local to Sioux Falls who's joining us as effectively Friday. So thank you for your time, everybody. And again, keep on trucking.
Thank you, everyone.